presidential immunity. I'm the one, through my petition in the High Court, E426 of 2020, who brought or dragged the President to court and asked for the orders that I asked for, based on Article 143, not exactly what I asked for. I simply said that you can institute civil proceedings against a president for actions that he undertakes or omissions outside his functions of office. In other words, Article 143, Clause 2 protects him, gives him immunity when he's performing the functions of office as president, functions of presidential office. When he was busy setting out Kenya Gazette notices, establishing the BBI authorizes him to engage himself in constitutional change matters outside Article 256. This, Article 143, Clause 2 did not prohibit us from instituting an action against him. And that is basically what I had asked for. Contrary to the Constitution, the pronouncement of the court was wider than what I had asked for. I had confined myself to conduct outside his functions of office. But if you apply what the High Court said, you can sue him for anything that he does that is unconstitutional. Unconstitutional includes both functions within his office and functions outside his office. And that is a bit that I disagree with. And if I am Justice Joel Ngugi or Justice George Odunga, who are involved with this matter at the High Court, because they ruled in the manner that they did, and the President doesn't like them because they scuppered reggae or they messed up BBI, his pet project, when other judges were being promoted to the Court of Appeal, they were left out. I mean, for us Kenyan citizens speculating, we say the only reason why they were left out was not because of their inability to act as judges, but it was simply because they came up to a determination that messed up the President's plans. Now, if I rely on that particular order from the High Court and the Court of Appeal, Justices Ngugi and Odunga can actually go ahead and sue the President right now, maybe in the Employment and Labor Relations Court, for the deficit in their remuneration compared to what they're earning now as High Court judges, compared to what they should be earning as Court of Appeal judges. And of course, they would have a case, because that particular order allows them to do that. The President acted unconstitutionally, violating Article 166, because once he has received a recommendation from the Judicial Service Commission, he's supposed to ceremonially appoint all those judges to office. He didn't do that. Now, we know every once in a while we see President Uhuru driving vehicles and everything else. He could commit a minor traffic offense just like anybody else. But because that particular criminal offense or traffic offense, as the case may be, does not fall under Article 143, Clause 4, 1e, Article 143 protects the rights of the DPP to bring any prosecution against the President, AG. The President does not have to get some clarification here. Article 143, Clause 2 gives him immunity against civil proceedings being instituted against him. It doesn't talk about immunity against constitutional proceedings. It doesn't talk about immunity against electoral proceedings. After all, we have presidential election petitions. The President is sued. He was sued by Raila Odinga in the last presidential election petition. And that was valid, and it was admitted before the court, and the matter was dealt with. In other words, we are only talking about civil matters. Constitutional matters can be brought against the President. Electoral matters can be brought against the President in his own name. We cannot have that. No. Who is boss in this country, I asked earlier on. Is it Martha Koome? Is it Uhuru Kenyatta? Is it Devin D? Or is it us, the people? Who is boss? If we, the people, are boss, then our word should rule and prevail. And if we put qualifiers in judicial immunity, like unlawful, not in good faith, we mean exactly what we say when you put those particular phrases in the Constitution. They're not to be ignored by judges. You're supposed to act faithfully in upholding that Constitution. That is the delegated authority we gave you, not to act beyond the authority we gave you. So Bellevue decision is wrong. Uhuru Kenyatta as president cannot rely on that in an effort to get himself absolute immunity. He does not have absolute immunity.